Hi again. Walter Rauschenbusch, page 256, Christianity and the Social Crisis. In the last segment, Rauschenbusch detailed how even President Roosevelt, that is Theodore Roosevelt, back at the turn of the century, had to stand up to the powers that already existed in the United States. And at the end of that section, he asked the question, Rauschenbusch did, have we a dual sovereignty so that our public officers are in doubt whom to obey? He goes on, here is another instance showing how political power is simply a tool for the interests of the dominant class. In 1891, the Working Women's Society of New York began to agitate for proper sanitary accommodations and seats for the female clerks in the department stores. This sensible bill was annually met and defeated at Albany by a lobby of the retail merchants. In 1896, it was at last enacted, and the right of inspection and enforcement was given to the local boards of health. For 18 months, it was enforced in New York in the most tyrannical manner to make the law odious. The Tammany mayor then appointed one of the owners of a great department store as president of the Board of Health. This man said that he desired the position partly to squash an indictment or quash an indictment against a certain philanthropic enterprise of his, and partly to paralyze the mercantile inspection law. The mayor suggested that the necessary appropriation be withheld, and so the law became a dead letter. To secure special concessions and privileges and to evade public burdens have always been the objects for which dominant classes use their political power. For instance, the feudal nobility of France originally held their lands as franchises from the crown in return for a tax of service, chiefly military, to be rendered to the nation. When the old feudal levies proved inefficient in the Hundred-Year War with England, a standing army was organized and supported by a money tax. The nobility were thereby relieved from their old obligation of levying and supporting soldiers, yet they successfully evaded their share of the tax. This is merely a sample case. It can safely be asserted that throughout history, the strongest have been taxed least and the weakest most. The same condition prevails in our country. The average homes in the cities are usually taxed to the limit. The most opulent homes, and especially their contents, are taxed lightly. Vacant lots held for speculation are often flagrantly favored, though they are a public nuisance. In 1856, taxes were paid in New York State on $148 million worth of personal property over and above the capital of banks and trust companies. During the following 40 years, the increase in personal property in the state was immense, yet in 1896, the amount found for taxation had increased by only $66 million. In that year, a study was made of 107 estates taken at random in the state of New York and ranging from 54,000 to 3.3 million. After the death of the owners, these estates disclosed personally aggregating $215 million. But the year before their deaths, the owners had been assessed only $3.8 million on their personal property. 34 of them had escaped taxation altogether. An investigation by Professor E.W. Bemis in Ohio in 1901 showed that while farms and homes were assessed at about 60% of their value, railways were assessed at from 35% down to 13% of the market value of their stocks and bonds. The interests which thus evade taxation have usually been enriched by public gifts, by franchises, mining rights, water rights, the unearned increment of the land, etc., and yet they allow the public burdens to settle on the backs of those classes who are already fearfully handicapped. The courts are the instrument by which the organized community exercises its supremacy over the affairs of the individual, and the control of the courts is therefore of vital concern to the privileged classes of any nation. Exemption from the jurisdiction of certain courts, which would be troublesome, was a desirable privilege, and both the feudal aristocracy and the clergy had that privilege. To a wide extent, the feudal nobles down to our own time had the right of jurisdiction within their own domains, and when they sat as judges, they were not likely to hurt their own interests. The English landowners long made the law in Parliament and interpreted it in the courts. The terrible punishments visited, for instance, on poaching are a demonstration how they dealt with offences against their cherished class rights. In our own country, all are equal before the law, in theory. In practice, there is the most serious inequality. The right of appeal, as handled in our country, gives tremendous odds to those who have financial staying power. The police court, which is the poor man's court, deals with him very summarily. If a rich man and a poor man were alike fined $10 for being drunk and disorderly, the equal punishment would be exceedingly unequal. If the poor man is unable to pay the fine, he gets 10 days. Nothing likely to be inflicted on the rich man for a similar offense would hit him equally hard. I'll put the link into the playlist, actually, which has now gone to over 100 videos. Walter Rauschenbusch, Christianity and the Social Crisis.